Napho sebengene bonke abantu.
Oh, okay. Bye.
Nangu chairperson ukhona.
Hawu, sihlalo wami kunjani?
Hello, Ma. How are you?
Okay, and yourself?
Oh, no. Siyaphila. Good morning,
Hayi,
everyone. Hi.
Good morning, Chair.
Morning, Chair.
Yo, niyaphila, nikahle?
Siyaphila sikahle, Chair, wena unjani?
Siyaphila.
Morning, everyone.
Good morning, Benedict. How are you? Oh, sorry. It's Honorable Van Minen.
We have builders, is all I'm going to say.
We have?
Builders.
Oh,
So yes, it is what it is, eh?
it is. Sistambi, it's 10 o'clock. Are we good to go? Can you just check where the other members are? They're managing to connect so that we can dive right into it. 1, 2, 3, 4. Yes, Dombi, can you just give it a few minutes and just check on members and then we'll start.
Good morning.
SS, good morning.
Good morning, sir. How are you? Hoe gaan dit agbare, voorzitter?
Ach nee man, ik praat Afrikaans nou. Hier, wat gaan aan achtbare bukes? Is this your teaching? All right, I think we are.
Good morning,
right.
good morning.
Good morning, everyone. All right, now I think we're good to go. Mazambane just came in. Absomyo, Lubengo, Fanmine, Natebe, Bukes, Zibula. All right. Okay, colleagues, good morning and welcome to our meeting this morning. There is proof of life. I'm going to keep my camera off. Network is a bit unstable. So this morning, we welcome back to the fourth term of Parliament. We deemed it prudent to rather meet virtually this week because there's no sittings in the afternoon. So hopefully we'll be able to all have network for today.
Recording in progress.
And tomorrow on the matters that are before us. So that's just the only reason why really we thought it best to just meet virtually. So I hope this works for all of you colleagues. Colleagues, this morning we're going to get a briefing from Parliament Legal because in September, the committee had wanted to get guidance and advice on the matters around Brigadier Berger on the Eskom related matters following a letter that he wrote to the Speaker wherein he sought to say that we as a committee were not empowered to deal with the matters of which were in his purview in the investigation on the Eskom matters. As you know, that we've been dealing with the allegations made around by the former CEO of Eskom. And so to bring this matter to a conclusion and a clarity, because the powers of the committee were being challenged and our jurisdiction was being challenged. So the legal advice was circulated to members over a week ago. So what I'm going to do, colleagues, can we ask Advocate Jenkins to take us through that, the salient points, and then we take a decision on this matter. So really the item this morning is just that one particular aspect, because I think it's important that there's clarification, even if whilst there is clarity, but because we were challenged that we put it on record. So Advocate Jenkins, I'm going to hand over to you and then colleagues will come in for discussions after. And as I've said, the legal opinion and guidance of Parliament Legal Services was circulated over a week ago. So colleagues, good morning and welcome. On a lighter note, we congratulate Pirates on a wonderful victory on Saturday. Advocate Jenkins, over to you.
Good morning, Chairperson and honorable members. Light is not so great here. I'm trying to screen share so I can put the, I think there it is. May I have confirmation that?
Yep, it's up.
Okay,
Yeah,
thank you very much. So, Chair, yes, welcome back and thank you for this opportunity. We provided this legal advice last term or in the third term. And it results, Chairperson, if I can start with the introduction, we were requested to respond to this letter that Brigadier Jaap Burger sent to the Speaker that he cannot avail himself to appear before SCOPA or to answer questions in relation to SCOPA's ongoing inquiry into allegations of corruption, criminal activity and malfeasance at Eskom. So, Chair, for where we are now, the legal question that we need to answer, which we looked at in any case, is to look at the reasons for his refusal to voluntarily avail himself for questioning and whether there is, based on that, a legal basis to summons Brigadier Burger to appear before SCOPA, notwithstanding the reasons that he has provided to the Speaker. Now, Chair, the brief background, and we are aware of the interview Mr. De Ruyter, the former Group CEO of Eskom, gave to ENCA, which he made certain allegations. And in that interview, Chair, and that's the part, he said the following, that his office has full access to all the intelligence gathered. The officer of South African Police Service, which he liaised with, had full access to all the intelligence gathered and has stated to Mr. De Ruyter that he has kept his line of command informed of all the information that Mr. De Ruyter has passed on to him. So, Chair, based on that, it then transpired that the person liaising with Mr. De Ruyter was Brigadier Burger from the South African Police Service, who has recently retired. And then Brigadier Burger was requested to, of course, as you well know, to appear on the 7th of June before SCOPA. And at that meeting, the head of, I think, police, Jerome Masemola, informed SCOPA that Brigadier Burger had concerns about appearing publicly because of certain safety concerns. And then Brigadier Burger sent the letter to the Speaker highlighting two reasons why he can't appear. And one is that Eskom is a national key point, and that SCOPA does not have a mandate to deal with national security matters. And he noted that security competence requires that classified information or material should not be allowed to fall into unauthorized hands and thereby harming and endangering the security interests of the state. Specifically, Brigadier Burger contended that security matters, in particular investigations into organized crime and corruption, are classified in nature. It's not open until it reaches a court. And he noted that there's a safety concern in respect of the investigators, the whistleblowers, the witnesses, and collaborators. So, Chair, that in a nutshell, and therefore he questioned, let me add that in there because we deal with that at the end of the opinion. He also questioned whether the allegation should not be dealt with more appropriately in a closed meeting by the Joint Standing Committee on Intelligence and all other portfolio committees like the Portfolio Committee on Police, Justice and Correctional Service, or the Portfolio Committee on Public Enterprises, which all have a specific mandate regarding crime as well as Eskom. So, Chair, maybe if I can just set out to the members what we did with the opinion, we then just looked at, first of all, what is the mandate of SCOPA? What can SCOPA do? And then from there, we looked at the general power of find out whether SCOPA has the authority to summon somebody. And then we looked at the reasons Brigadier Burger preferred to the Speaker for not appearing, and we deal with this below now, Chair. So the mandate of SCOPA, Chair, I think most members are aware of it. I think it's summarized best to say that SCOPA as we can see in the ATC and so on, receive all the audited financial statements of government departments as well as entities. And it then investigates those financial statements. It looks at unauthorized expenditure, irregular expenditure, and asks whether certain steps have been taken to address these irregularities and whether steps have been taken to prevent it from happening. So that's the general power of SCOPA, and it can be summarized there in paragraph 9. So SCOPA is accordingly mandated to conduct financial oversight over all organs of state. That, in a word, needless to say, there's always been a overlapping of functions between various portfolio committees and SCOPA, and that is intended. There's not one government department that can say we account only to one specific portfolio committee. The accountability it has towards Parliament. It could be a number of committees, and a number of committees have certain duties to oversee government in various departments. So if we now check, that's just, as I said, the general mandate of SCOPA. One can continue with that, just the general power of committees, including SCOPA, in terms of Section 56A of the Constitution, as well as what we see in the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act. Committees may summon any person to appear before it or to produce documents, and it's a information gathering tool to facilitate and strengthen the execution of the mandate of Parliament, specifically the National Assembly and its committees, to deal with or to gather information, as well as when people do not want to appear, to force them to appear and to share that information. So, Chair, that is the background to this matter. What we're doing now next is to look at the specific reasons given by Brigadier Burger not to appear. The first one you indicate is that Eskom is a national key point, and therefore he can't disclose information about Eskom. In our research, Chair, we found that Eskom as an entity is not a national key point for the purpose of the National Key Point Act, but certain power stations under its control have separately been declared as such. So this we got from the press statement, and the reason itself, or the reason for declaring those as national key points by Eskom has given that itself, and we deal with that below as well, Chair. So I think important for going forward with this opinion is to see that Section 10 of the National Key Point provides that it's an offence for a person to furnish information relating to the security measures applicable to a national key point in respect of any incident, or in respect of any incident that occurred there. So even if a entity or a power station in this instance is declared a national key point, it's only illegal or contrary to the legislation to disclose information if that information relates to security measures applicable or in respect of which an incident that occurred there. Unless, of course, and even there is an exception to that rule, unless a person is legally obliged or entitled to do so. If you're not, then you will be guilty of an offence. So there is a balance that's been struck there in the National Key Point itself. Now, just for information, the National Key Point Act has been repealed by the Critical Infrastructure Protection Act of 2019, but that latter act has not come into operation. So we're still looking at the National Key Point Act. And one can say that the General Burger is correct to reference it because it is the correct piece of legislation at this time. The second reason that we need to interrogate that was preferred by Brigadier Burger is the issue that questions may compromise security information, which may violate national security. So in the next part, we're going to look at what is national security in terms of legislation, and what is the and compared to what is it that SCOPA is looking for. So the legal requirements in respect of national security information is a bit of a disjointed collection of legislation we'll have to look at. And we start with the 1982 Act, the Protection of Information Act. It's an apartheid era legislation that protects certain information of the state, and Section 4 there provides that it's a criminal offense for any person to disclose information relating to the defense of the Republic and information regarding a security matter. Now, security matter is again defined as matters dealt with by the intelligence services or relating to its functions. Chair, we put that there aside. We're going to try and build a sort of a conceptual idea of what is national security. We're looking now, secondly, at the Promotion of Access to Information Act. Now, that act, as honourable members might know, is there to assist with the dissemination and the access to information rather than to prevent access to it. But nevertheless, it's helpful to look at it because PAIA, if I can call it PAIA set certain standards for national security matters, which will then be exempted from disclosure. So Section 41 of PAIA deals with the mandatory protection of information relating to the defense and security of the Republic and provides that the most comprehensive legal framework for what would constitute information relating to national security. So we quote Section 41 in full, at least 41.1, that deals with these mandatory protection. And we want to say upfront, there are certain exceptions to this general rule as well, which we'll deal with afterwards. Now, Section 41, Chair, of PAIA provides now what we'll say is the definition or what it is that we cannot disclose. So examples of records that's going to cause prejudice to the defense of the Republic or the security of the Republic include military tactics or strategy or military exercises. I'm just going to be brief, Chair. The quality, characteristic, capabilities, vulnerabilities, or deployment of weapons or any other equipment used for detection, prevention, or suppression of such subversive or hostile activity. So it's really combat ready, it's operational security matters. It goes a little bit broader towards the end, the characteristics, capabilities, vulnerabilities, and performance and potential deployment or functions of the military force. Information held for the purpose of intelligence relating to the defense of the Republic, detection, prevention, suppression, or curtailment of subversive or hostile activities. So it's not just the actions and the plans, but also then other intelligence. It goes a little bit broader towards the end, as I said, methods or scientific or technical equipment for the collecting and assessing of that information. So this will be intelligence gathering tools, if I can call it that. Identity of a confidential source, of course. Positions adopted, and this is a little bit different, the G and H. These are positions adopted by the Republic when we are going to vote or participate at certain international organizations. And then also what would we call diplomatic correspondence, exchange with another state or international organization, or official correspondence exchange with diplomatic missions or consular posts of the Republic. And this information, except if it falls within the exception, which we'll deal with, must not be disclosed. So to understand the reason for Brigadier Burger not appearing before SCOPA, we need to understand what is national security and what is the ambit of that, just to bring us back why we're going through Section 41 of this Act. So notwithstanding that security information is contained as an exception to the general rule of disclosure, Section 46 contains a public interest override. So Section 46 overrides even these issues which I've raised now, if the disclosure would reveal evidence of a substantial contravention of or failure to comply with the law, or imminent or serious public safety or environmental risk that the public interest in the disclosure of the record clearly outweighs the harm contemplated. So again, there's a weighing up of issues. And if the issue of public harm or public interest outweighs it, that safety and security issues are overridden. Sorry. So the next act we want to look at is the National Strategic Intelligence Act, which defines national security as intelligence which relates to or may be relevant for the assessment of any threat or potential threat to the security of the Republic in any field. So national security in turn is then defined in the Act, and it basically deals with the threat or use of force against the Republic, and then there's certain other acts which we list there: hostile acts of foreign intervention, terrorism, espionage, exposure of a security matter with the intention of undermining the constitutional order in the Republic, etc., etc. But it does not include political activity, advocacy, or protest or dissent. So, Chair, in terms of the National Strategic Intelligence Act, these matters or these issues form what I would call or delineate the issue of national security, to understand what it means. And when we go now to a document often referenced in Parliament, because of the sort of disjointed or the omnibus nature of our security legislation, the Minimum Information Security Standards. It's a policy document adopted by Cabinet in 1998. According to this document, sensitive information which is in the national interest is held by or is produced in or is under the control of the state, or which concerns the state, in which must by reason of its sensitive nature be exempted from disclosure and must enjoy protection against any compromise. All this information must be classified. So MIS deals with classification and declassification of information. So what I've just read out is information that needs to be classified. Now, again, I can say we do not know the information that, the exact nature of the information required by the committee. We have an idea of that, of course. Whether this information is classified, we do not know, although Brigadier Burger has indicated that it falls outside the area of transparency. So I'm just wanting to make that point at this stage. So again, let me continue. Clause 3.4 of the MIS policy clearly states, and again there's an override, that security measures are not intended and should not be applied to cover up maladministration, corruption, criminal actions, etc., or to protect individuals or officials involved in such cases. So again, there's an override or an exception to the rule when it comes to criminal conduct. Chair, what's further important for this discussion is Section 70 of the South African Police Service Act, which makes it a criminal offence for members of the South African Police Service to willfully disclose information in circumstances in which that person knows or could reasonably be expected to know that such disclosure will or may prejudicially affect the exercise or the performance of the police of the powers and functions referred to in Section 205 of the Constitution. Section 205, for interest's sake, lists the functions of South African Police Service to prevent, combat, and investigate crime, to maintain public order, to protect and secure inhabitants of the Republic, their property, and to uphold and enforce the law. So no police officer may, in terms of Section 70, willfully disclose information which may prejudicially affect the exercise of these powers. So, Chair, now we're going over to the discussion just to see which. Returning to the correspondence from Brigadier Burger. Now, we're going to deal with two questions. One is flighted there in highlighted. Is SCOPA legally mandated to question or receive information relating to Eskom from Brigadier Burger? So, considering the questions that might come forward, is it within SCOPA's power to execute these questions and to ask Brigadier Burger this? For members of the committee, of course, the principle of legality requires that we do this, because no organ of state or official of the state can perform any function which that person is not allowed to perform in terms of law. So for SCOPA to ask the questions, it must be allowed in law to ask these questions. The second question, which we will deal with after that, is if Brigadier Burger refused to appear before SCOPA, can SCOPA summons that person? Okay, so the first question, Chair, which we've dealt with when we looked at the mandate, is that when we're looking at SCOPA, it's clear that there's a distinction between SCOPA and other PC and other portfolio committees in their role, because SCOPA is more of a specific oversight role over the financials and financial management, compliance with the financial management of the Public Finance Management Act, as well, whereas other portfolio committees will have a broader view of an entity. For instance, the Portfolio Committee on Public Enterprises will look at various aspects of governance and performance issues within Eskom, whereas maybe to reach targets that's set in the national development plan and so forth, implementation of the State Capture Commission recommendations, etc. Chair. Whereas SCOPA will then specifically be on financial oversight. So given this sort of not with the Chinese wall division of powers of committees within Parliament, what is SCOPA's mandate, and can it then ask these questions to Brigadier Burger? Chair, I think what is critical at this point in time is to understand that there is no committee, and it was, as we said earlier, there's no committee in Parliament which has got an exclusive relationship, and I'm saying this in general, an exclusive relationship with the government department. As functions of government department overlaps or dovetails, so different committees can have an interest in that department. So when we're looking at SCOPA, Chair, and we ask the question here at paragraph 25, I can go here. Here we ask the question. It's unclear why Brigadier Burger is saying it's more appropriate to go to the PCO and public enterprise or police with this information, when all these committees, in fact, except the Joint Standing Committee on Intelligence, are, as a rule, open to the public, and information must be discussed in a transparent manner. So whichever systems the police, the PCO and police can do to assist Brigadier Burger to disclose information, SCOPA can do the same. So that's a question we ask. It's not clear why it can't be SCOPA, because SCOPA has that mandate to look at the financial oversight. So questions on irregular expenditure, questions on unauthorized expenditure, questions on why it happened, what steps have been taken, who was involved, and what is done to prevent it. All those questions fall within the mandate of SCOPA. So I'm going to read paragraph 26 for the committee. So given that SCOPA is responsible for the oversight of the financial expenditure of public funds through engaging with and interrogating the financial statements, audit and other expenditure reports of organs of state, including Eskom, it may further investigate and consider any such matter related to the same. Now, by way of example, SCOPA can consider whether there has indeed been unauthorized expenditure, irregular or fruitless expenditure, and wasteful expenditure at Eskom. In other words, what financial maladministration has taken place? Were there any contraventions of the Public Finance Management Act? Whether such expenditure was accurately recorded? Was it properly identified for audit purposes? And whether action has been taken? What was the status of such action, and whether any remedial measures have been put in place to detect and manage similar future occurrences? So all these questions would be in pursuit of SCOPA's oversight mandate, because it all focuses on financial management issues. So on the face of it, Brigadier Burger's role would be limited, therefore, to providing information around these issues, allegations of financial misconduct that were reported to him, and the nature of that financial misconduct. And then as well, what steps were taken, what reports were made, what's the status of the investigations, and so on, Chair. So whether criminal action were pursued against the alleged perpetrators, and if not, why not? And what the status of those investigations were at the time when he retired. These questions, in our view, fall within the mandate of SCOPA. So the generalized defense raised by Brigadier Burger, that the information relating to Eskom amounts to information on national security and organized crime or corruption, and that SCOPA is not legally entitled to consider the same, without explaining why other portfolio committees are more relevant to consider those questions, we don't find that is a sufficient basis to refuse to appear before SCOPA, Chair. The issue of the Joint Standing Committee of Intelligence, because it holds its session in closed session, that's preferred by General Burger. Yes, that is a good option if the information is relating to matters that's been discussed by the intelligence services, by the SSA and so forth, Chair. So we're actually saying in section 28, we don't know exactly what the questions are going to be and what information or how the responses will be and the follow-ups on that. So we need to just be very clear where SCOPA's mandate lies with the financial oversight matters and not go into the intelligence matters, because that would be JSCI matters. So Chair 29, I'm going to read out again. Sorry, I'm not so good with the, no, there we go. The question is thus, we are at paragraph 29. The question is thus whether the information related to the allegations made by Mr. De Ruyter amount to information on national security, and therefore, notwithstanding that it relates to financial maladministration, whether SCOPA is precluded from receiving such information. So we don't know the information, but that's a critical part. I mean, if it falls within SCOPA's mandate, if it's about the irregular expenditure and the steps taken, as I've just read out, we feel that falls within SCOPA's mandate. The issue of that, at paragraph 30, the issue that Brigadier Burger raises of Eskom being a national key point, and therefore all information relating to that is protected. We don't find that is supported in law, Chair. The fact that an entity owns a property that's declared a national key point does not automatically exempt all information relating to financial maladministration of that entity from being subjected to open and transparent oversight processes. It really offends the constitutional principle of openness and transparency. And the fact that the power stations have been declared as national key points in itself does not justify a blanket refusal of any person to account on the financial matters of Eskom. We might add, and we mention it there, that Parliament is also a national key point. And if the Secretary to Parliament would refuse to appear before the Joint Committee on the Financial Management of Parliament, saying that Parliament is a national key point and therefore all information is privileged, it would be an absurdity. So the same applies to Eskom. So it's really not about the fact that you are a national key point, it's about what information is requested. So the question should rightly be whether the disclosure of the information relating to the allegations will compromise or threaten security of that individual power station. Remember, that's the provision we read in the national key point. Person may not willingly disclose that kind of information of a national key point unless a person is compelled by law to do it. So if the information do not involve disclosure of information relating to security measures or of an incident that took place there and is therefore protected by the National Key Points Act, that information can be interrogated by Eskom. So the Brigadier Burger's explanation there is not really, in our view, the end of the matter, Chairperson. We can return to the analysis we did before, Chair. I mean, even that information, is it really there to safeguard national security interests? Because that is sort of the delineation of this issue of security matters. Again, even that information, it cannot be extended to avoid accountability or protecting individuals. From our understanding of the allegations, there's no reason to believe that Brigadier Burger would not be able to share information in a manner which does not raise national security concerns. I think, Chair, I can just pause there. The Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act permits a witness to say, well, there's a certain legal impediment to me disclosing this information. In fact, what the Act requires is that a person called as a witness must answer all the questions unless there's a legal reason not to answer it. So even if the arguments of Brigadier Burger holds water, he needs to appear and then at the specific question indicate that that question is legally, I'm legally obliged not to disclose it. So from our general understanding, again, I'll say it, we do not think that Brigadier Burger would not be able to attend. We think that he can share information in a manner which does not raise national security concerns. Now, it's highly unlikely, if not impossible, that the totality of information constitutes information that, if revealed, would compromise national security as understood with reference to the protection of the Promotion of Access to Information Act and the National Security Intelligence Act, which we've referred to above. We've already mentioned that we don't have any information whether the questions and the records at Brigadier Burger's disposal have indeed been classified for the purpose of missed documents. And if so, SCOPA can, of course, apply to have that declassified so we can look at that information and follow the processes set out in the missed document. Of course, Brigadier Burger cannot declassify. He's retired, so he can't do the declassification. But we're dealing now with that specific question. If the information has been classified, it can be declassified. If it's classified, again, we can look at the MIS document itself and say that even the MIS document says that classification cannot be used to hide corruption, maladministration, and criminal offences. So SCOPA, again, have the right to interrogate these matters and to look at that. If there was an abuse of the classification system in terms of the MIS document, Chair, then that itself needs to be interrogated, much like the State Capture Commission did, and mentioned it at a few places where the MIS document should not be used to get around the issue of accountability. Chair, I'm going to go to paragraph, I think I've rushed a bit here now, Chair. No, sorry, I'm going to wrong. So, Chair, let me just, sorry, I've lost my plaque here. The question should rightly be, Chair, yeah, we're going. Chair, we think that the information related to the procurement of goods and services or the non-compliance with financial prescripts, which are at the core of what SCOPA should focus on, will necessarily threaten national security. So we think that even those questions can be asked and should be answered without doing it in a way that threatens national security, in the sense of what we understood earlier to be basically part of operationals in an armed conflict, or gathering information or intelligence for that conflict, or then the international diplomatic correspondence between countries or international organizations. We do not think that the questions of financial management at Eskom falls within that category of information. So the Protection of the Information Act, in any event, we don't think it will apply there, and it must be understood in any event against the constitutional values of accountability, openness, transparency, as well as the public interest override that we get in this legislation. So at paragraph 36, it's advised that if Brigadier Burger is to appear before SCOPA, that he be sworn in and afforded the protection in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act. That's just the short term for that act. So that the information provided cannot be used against him unless it's for a case of perjury. Maybe just to remind the committee that the act itself affords the same legal protection to a witness in Parliament that it would give a witness in a court. So to encourage that witness to disclose and to answer freely and openly, they cannot be prosecuted on anything that they've disclosed before Parliament in that when they've been called as a witness and they've been sworn in, unless they've deliberately went and misled Parliament, which will then be a case of perjury. So we advise that the Brigadier should be sworn in when he appears. We also want to make the point here at 37 that Brigadier Burger raises security issues, his own personal security issues. Of course, we can't comment on that. We don't have information. We would think that it's best if Brigadier Burger does not compromise, of course, his own safety, or answer questions that he doesn't compromise his own safety. So in respect of his own safety, we say that the South African Police Service should be requested to advise whether they have conducted a security assessment to ascertain whether there is any threat to the safety of Brigadier Burger would be, and which would be compromised if he was to appear before SCOPA and answer questions related to the oversight mandate of Eskom. That includes also, of course, that he mustn't disclose information that would be in contravention of that Section 70 of the South African Police Service Act we referred to earlier, which says he mustn't disclose information that could compromise the ongoing investigations. So, Chair, that is the first question that we dealt with. That's the question, is SCOPA legally mandated to question or receive information relating to the allegations of Eskom from Brigadier Burger? And the short answer is yes, if it is around financial mismanagement. So we must be very strict on that. And Chair, that would be, I think, part of the duties of the Chair to manage the committee so that it sticks within his mandate. Now, Brigadier Burger has refused to appear already. question then arises, can Scopa summons Brigadier Burger to appear before? The answer again is yes, it is empowered. We've referred to section 56 of the Constitution. The fact that Brigadier Burger is retired is not an impediment from him being asked to provide oral evidence or to submit records. However, and I've said this before at paragraph 40, sorry, I must move on. It's not an unfettered power to summons a person to appear before a committee. The reason for requiring that person to come to the committee and to answer questions or to produce a document is specifically for the purpose of that committee performing its statutory and constitutional functions. So whatever information is the subject of the discussion at that meeting, it must fall within Scopa's mandate. Otherwise, the power of summons itself would not be properly executed. Chair, we make the point at 41 and 42 that power to summons is an extraordinary measure. The Supreme Court of Appeal has already said it is an extraordinary measure and it must be used as a measure of last resort. So there must not be an easier way to get that information other than to summons a person, because it is a limitation of someone's freedom of movement. So we say at 43, and we're saying this, we do not know exactly what has transpired in the meantime, but since we wrote the opinion, but we reckon that a further attempt should be made to secure the voluntary attendance of Brigadier Burger. And if he maintains his refusal, the committee may summons him to provide the information it seeks from him. And if he has that information, of course, and if it cannot be obtained in a less restrictive manner. In that less restrictive manner, we mentioned further on when we're going through the way forward, which is the last part of this opinion. We mentioned that if it is classified information, if it indeed could compromise national security, which we do not know at this point, then of course one can ask that he submits his written answers to the Joint Standing Committee of Intelligence, and that information itself can also be disclosed in Scopa if Scopa decides to close the meeting for that specific part, which would be classified. But otherwise, it can be in an open committee, Chairperson. So on the way forward, Chair, Scopa is legally mandated to consider information relating to the financial administration of Eskom, and these vague and generalized attempts to prevent Scopa from conducting its oversight responsibilities and ensuring accountability of state institutions. In law, we reject that, and the issue of classification, the issue of secrecy should only be allowed in cases which is really clear. So in our view, Chair, again, if we ask Brigadier Burger to come forward, if he maintains his refusal, one can actually ask also specifically what information is classified, what information will threaten national security, because the idea of as we've analyzed in the opinion, the idea that it's simply a national key point does not hold water in law for us, Chair. So we reckon that there's no reason why Brigadier Burger cannot account and raise and the issues of national security that he raises can be dealt with if it is indeed issues of national security in a confidential manner. Chair, I'm going to leave 47. That's really for the chair to the committee to decide, because the issue is Scopa will need to ascertain whether the information it seeks, what questions exactly is it that Scopa wants to ask Brigadier Burger, and those questions need to relate to the accountability of Eskom in line with Scopa's mandate on financial oversight. And then we must ask whether Brigadier Burger is the correct person to provide that information to Scopa. So, Chair, that is a matter that paragraph 47, and one can make a note on that the committee needs to deal with. And then we give some guidance on the way forward. Now, if Scopa resolves to summon Brigadier Burger to provide written or oral evidence, such engagement must be based on the understanding that the information sought by Scopa is not available from another person, that it is within Brigadier Burger's personal knowledge, or there's no other less restrictive means to get that information. The information must be for the purpose of and pursuant to maintaining oversight of Eskom in relation to the expenditure of funds. Again, we make the point that it's not the role of SCOPA to deal with any alleged ethical breaches of any member of the executive or deal with operational and policy issues relevant to Eskom, which is the responsibility of the PCO and public enterprises. The focus should be on what information Brigadier Burger has in relation to the allegations that can assist SCOPA in fulfilling its financial oversight mandate. So the engagement must be limited to the extent that Brigadier Burger is not compelled to answer questions which will undermine national security. Understood in the sense of the Promotion of Access to Information Act, neither must it be a contravention of the Protection of Information Act or the MIS policy. And again, we make that point at 48.4 of Section 70 of the SAPS Act. He needs to be sure that he does not contravene that part, and that is around the investigations conducted by SAPS. And the sub point at 5 follows on that. It must be limited to matters which will not potentially prejudicially affect the exercise of the performance by SAPS of the powers of their function to investigate offences. In this regard, we note the concerns raised by the Special Investigation Unit that certain information, if revealed, may jeopardize ongoing investigations. That has been said before, and we need to take note of it. We think SCOPA should not go into that area where the information seeking to fill its mandate jeopardizes those investigations. But it does not limit your obligation to account completely. And to share information, even in a manner that we take then cognizance of the sensitive nature of it. And at 49, Chair, we make the point I've mentioned before that SCOPA can also try to liaise with the JSCI so that Brigadier Burger table a written statement there, should the information be of such a nature that that's the only avenue where SCOPA can get that information. Chair, that is the end of the opinion. Thank you very much.
Right, thank you very much, Advocate, for that very extensive presentation. Of course, we've invited Brigadier Burger twice now to appear before us. And, well, here we are. All right, colleagues, let me come to you. Please just indicate through the WhatsApp group or the raising of the hands on the platform. I don't see any hands. But Honorable Liz.
Good morning, Mr. Chairman, and to everyone else present. Yeah, thank you very much to you, Frank, for your presentation. Mr. Chairman, it seems quite clear that the SCOPA should now move ahead with interviewing Brigadier Burger. The methodology of getting him before SCOPA seems to be clearly either a third invitation together with the legal opinion that Frank has now explained to us, explaining that SCOPA believes that he does not have sufficient grounds not to appear before SCOPA, and asking him to therefore now reconsider his decision, failing which, after a relatively short period of time, SCOPA should embark on a summoning procedure, and once that is on its way, obviously there will then need to be very cautious proceedings in terms of how they're conducted, and so on. However, I would suggest to you, Mr. Chairman, that it would be completely wrong to subject the committee to prepare questions in advance for Brigadier Burger, given that we don't do that for other witnesses or other interviewees, who also, from time to time, may be asked questions that may have some impact on investigations by the SIU or security matters and so on. It would be up to Brigadier Burger in the event that he felt that a question put to him were prejudicial in some way, to explain why that was the case, and for Scopa then to take a position on it. So, Mr. Chairman, to preempt any move to ask the committee members to prepare questions in advance to be submitted to Brigadier Burger, I think that would be out of order. The process, as Frank has explained it, can be handled at the meeting, and I'm sure you're up to it, Mr. Chairman, and I'll try not to be too grumpy. So, Mr. Chairman, the bottom line is that in my view, in our view, we extend a third invitation together with the legal opinion to explain why we believe that he should now appear before Scopa. Give him, let's say, 14 days or even 7 days to reply, and thereafter, depending on that reply, either schedule a meeting or proceed with the summons. So that would be our view. Thanks very much, Mr. Chairman.
Thank you very much, Honourables. Honourable Van Minen, and then Honourable Hattab and Honourable Somyo, in that order, please. I think you muted, Honourable Van Minen.
Can you hear me now?
All right, there you go.
Sorry, I've been using earphones. Oh, heavens, sorry. Now everything just decides to go a little odd. So we've got builders and renovators. It's all a little strange this morning. I want to agree with the Honourable Lees. I think that we've been very patient with Brigadier Burger, but we are now at the point where I think we do need to proceed in terms of his legal opinion. And thank you very much for the legal opinion. I think it puts it well. I would suggest, though, that we don't have any more than 7 days between the initial letter and the follow-up of a summons. I think that we now need to move forward with this. We have extensively dealt with a number of role players to do with the Eskom issue, and it's something we need to finish before the end of this term, certainly. I also agree in terms of the questioning. You know, we've now been in Scopa in this particular parliament now for 4 years. We have dealt with sensitive issues before. I think we're very aware of what we're looking for in particular with these Eskom meetings. And we do understand the ambit of what we would need to ask him. And it's not as if we're trying to uncover police procedural investigations. It relates to very specific issues that we have discussed with, among others, the police commissioner, the board, with various executives. And I think that we certainly do need to get the perspective of Brigadier Burger. And I'm very glad to see in terms of this opinion that we can do so. I do just want to note, Chair, that at some point, we will also have to come back to the issue of asking why the police commissioner sought to give us, should we say, inaccurate answers as to the first incident when Brigadier Burger did not appear, and his apparent inability to find where Brigadier Burger was. But certainly going forward, I think we need to send that letter, followed by a summons if we don't get a satisfactory response, and then have the meeting where I think it's pretty self-evident that Scopa knows the bounds at which it needs to be restricted. And I certainly don't believe we need to have a prior meeting to determine the questions, because I think we all know exactly what we need to do. Thank you.
Right, Honourable Hattab. Thanks, Honourable Van Minen. Honourable Hattab.
Yes, no, sorry, Chair. I'm using my cell phone device. Thank you, Chair. And also thanks to the advocate. Honourable members, let me greet you all in the wonderful name of Orlando Pirates, the mighty Sea Robbers, as Gamagepu, Chair, I think we wanted to engage Brigadier Berger precisely because at the time when we were engaging the National Commissioner, he is the one that brought the name of Brigadier Berger to us and indicated to us that some of the questions which the National Commissioner was unable to ask, the matter was referred to Brigadier Berger as the person that was charged and responsible for dealing with Eskom allegation. Secondly, we are not interested in dealing with any information that might be termed classified, and such information should not be made available or shared with us. I think having gone through the legal opinion and the presentation by Advocate Berger, and in terms of our mandate as SCOPA, we have been able to establish the locus standi, meaning the right for SCOPA or the capacity for this committee to be able to subpoena Brigadier Berger to appear before us and answer to all questions as it relates to financial misconduct and misappropriation of public funds. We are therefore, Chair, clear on what needs to be done and the way forward. Ours, Chair, I must state it categorically clear that we are only interested in allegation made by Mr. Director about certain individuals misappropriating taxpayers' fund and certain individuals permitting or causing funds to be misappropriated within Eskom. We want to get an understanding from the Brigadier what action was taken against those individuals that were alleged to have been part to the misappropriation of taxpayers' money. And if there were no actions taken, what were the reasons for no action? That's all we're interested. And he ought to explain to us, as a person mentioned by the National Commissioner, who was given that responsibility, upon receiving such information, what did you do, steps taken, and what is the latest update, the status of such investigation? For us to be able to fulfill our mandate and to conclude on this matter, we need such information to be shared with us. That's the long and short of why we want Brigadier Berger to appear before us. I would have gone to say, let us subpoena him once and for all. We have given him enough time, but I'm persuaded by the posture of the Democratic Alliance that let's, for the last time, forward to him the legal opinion and implore and appeal to his conscience for him to appear before us, and we should give him 7 days for such. And if he refuses, the process should be kick-started to subpoena him in order for us to fulfill our constitutional mandate and protect the public funds. And those that are responsible for stealing the taxpayers' money must be brought to book once and for all. And then we close this chapter and we move on. Thank you, Chair.
All right, thank you much, Honorable Somyo, and then Honorable Mente.
Good morning, colleagues. Let's just show life.
Yeah,
on my
proof of life. Hayi kumnyama sikuboni.
That is the proof of life. Is indeed proof of life.
All right, don't proceed. All right, Bob Somyo, you are muted. Just turn your... There you go.
Thank you very much, Chair and colleagues. The legal opinion is very clear and thorough. It does not in any way alter our original position of inviting Brigadier Berger to appear in front of the committee. So there's absolutely not a a single area which does look contrary to our original position. So we really need to somewhat continue to ask him to appear before our committee, meaning therefore that we need to correspond with him and advise him that we are not persuaded in any way otherwise, and therefore would somewhat plead with him to appear. That in itself indicates that our call and our invite is not in any way present any Malay directive, because his appearance and what we have sought is as a matter of consequential instances, and therefore we are not necessarily pursuing him on what he somewhat views as something which could be brought into what he thinks it is. And secondly, what we need to bear in mind is that in the first instance of his refusal, without our knowledge, the commissioner did place in front of us an apology, which sought to clarify his absence on that day. And his absence was further disputed by him through a correspondence to the speaker, which we were copied, as of not necessarily carrying such reasoning. So the part which the advice is carrying on the safety, he disputed it. It's not because of feeling unsafe that he is refusing to appear in front of the committee, and therefore the reasoning for that apology falls off, and therefore the reasoning for the legal opinion in that matter falls off. And thirdly, the instance that relate into questions that ought to be carried on the day, we have massified the actual areas which relate to his appearance as we need it, and it's a fact that our interest has never been the interest on any matters which he really feels are matters which ought to be handled by the intelligence or any other agency. The only areas which I think we really need to deal with are the same areas which is trying to run away from. So it's clear that Brigadier Berger knows very well that the information that he carries is the information which is somewhat of need for the committee to finalize its own chapter around the matters of looking into what bedeviled Eskom. Lastly, is the fact that the question of subpoenaing him should then follow after the correspondence immediately, if he still feels that he stands by the way of his voluntary appearance. Ours has been patience, which has been somewhat demonstrated by how we have behaved right through, by persistently corresponding with him with trust, knowing very well that whatever we need from him is basic information which is going to empower us to decide on matters which relate to what has been raised by the primary source or individual, which is the former CEO, Mr. Director, in this instance. So I really would want to agree with colleagues that there's nothing that would stop us, as it has been our belief in inviting him so that he could be of assistance in the closure of the whole matter that relates to these areas in as far as Eskom challenges are concerned. Thank you very much, Honorable Chairperson.
Right, thank you, Bob. Thank you much, Bob Somi. Honorable Mentor will be the last one.
Thank you very much, Chairperson. I don't know if everyone can hear me very well. My network is not so well.
Loud and clear.
Thank you very much, Chair. No, Chairperson, I think I'm going to present a completely a different view from what the colleagues are presenting. I think we are faced with a situation of someone who has made up his mind, in a sense that he undermines not only the authority of SCOPA, but he undermines the authority of Parliament as a whole. Like the legal practitioner has reasoned with us, that irrespective of it was SCOPA, the PC on police, or the PC on SOEs, he had to come and explain what he knows and what he does not know. But here we're facing a situation of a human being who has taken a responsibility and a position which then requires him to come and account to Parliament on whatever is required of him. And now for him to be sending us from pillar to post, for us to go at pain in explaining ourselves in what we want from him, it's out of order. And it's actually very much undermining. He holds no right to be questioning, firstly, our authority, questioning, secondly, our mandate and everything else. And in actual fact, he is insulting us in telling us that we have no basis of inviting him. He knows much better than we do. We do not understand the law. We equally do not understand our obligations and our duties. Therefore, we have no obligation as SCOPA to send him a legal opinion that he already have disputed, and he has already made up his mind that is not going to come to us. All these other gimmicks of writing to a speaker and everything, he is trying to derail the process and everything. So one, the fact that he is in a position of a responsibility that seeks to strengthen democracy within the country, that he holds in the SAPS, and ensuring that investigations are carried through, crime is kept, and justice is served. He is derailing all those mandates that were given to him by the responsibility which he carried as an SAPS officer. And then number two, he's questioning our authority. Why should we then nurse the feelings of a person who has no interest of coming to explain himself to us? That he demonstrated that when he responded to us and disputed what the National Commissioner was giving to us as an apology. He had already demonstrated that he doesn't see Parliament. He has no interest of coming to account to Parliament, and in particular, he has no interest of coming to account to SCOPA, as SCOPA is the committee that does not know its mandate, and of which he doesn't see himself coming to SCOPA. Therefore, Chair, my proposal is that we need to go straight to the summon. We will be justified to use the route of a summon because there is no other remedy we can put in place now in persuading a person who has made up his mind. Therefore, we need to summon the person and not send another invite. He has already demonstrated that he has no interest of coming to us. Thank you very much, Chair.
Okay, thank you very much, Honorable Mentor. Honorable Hadebe just wants to come in quickly on a last bite. Honorable Hadebe.
Thank you, Chair. Now, I wanted to also indicate the importance of us indicating to Brigadier Becker that when we invited him the first time, his superior, the National Commissioner, has given him an instruction to attend a meeting, and not even once the National Commissioner raised issues that Brigadier Becker is raising. So in terms of our understanding, not even the National Commissioner holds the views that are expressed and shared by the National Commissioner. By the basis of the National Commissioner giving him a go-ahead and a mandate to come and appear before us, that ought to be indicated and stressed upon when we are communicating with him. Thank you.
All right. No, thank you very much, colleagues. I just want to point out one thing which is problematic. See, in both instances, when correspondence was sent through to Brigadier Becker, he's never written back to us. He's directed all correspondence to the Speaker with very little due regard for the correspondence that has been sent insofar as him being concerned. And of course, I hear that we must write to him one last time, and I would have been inclined to agree with Honorable Mentor that we issue a subpoena on this matter, also considering Parliament's own very tight schedule as we draw to year end. We've been saddled with the data allegations now since April, insofar as committee process is concerned. So I can only hope that we will be able to bring this matter to a logical parliamentary conclusion so that we can be able to report to the House on this matter. Because by all indications, all is not well in the state of Eskom. If you consider now the latest developments of the departure of the board chairperson, it's just a lot of instability and back-on-back resignations and departures of senior persons in various streams of the Eskom establishment. And for me, that on its own is indicative of the extent of the problem. So I do think we need to move with a particular speed and urgency. So I just want to make one request, colleagues, that noting that the prevailing consensus is that we invite Brigadier Becker one last time and give him 7 days. I would request that we resolve on the subpoena today, that in the event that Brigadier Becker does not avail himself, we then proceed with the subpoena process. This will help us manage this and close on this matter, and it's going to have a material impact on the program of the committee. So today being Tuesday, Advocate, do we give him 7 days or 7 working days so that there's a particular legal clarity on that matter?
Chairperson, I mean, I would want, from my side, I'm not aware of what his schedule is. If I would get a subpoena, I would think that 7 days warning, working days, would be sufficient at least to respond to say, I am not available on this date in the event that that is the matter. Can we make it on another date? Because that's also a possibility. So I think 7 working days is sufficient time for someone to respond. Thank you, Chair.
Okay, all right. So that's fine. All right, we will invite Mr. Berger and expect Brigadier Berger and expect his response within 7 working days, effective from today. We'll dispatch that correspondence, and in the event that he is not agreeable to appearing before the committee, then a subpoena will be issued. I hope that summary suffices. We will look at the program for a date. I think the tentative date is to be the 21st for him to appear. The invite, just assist me there. Advocate, I see your hand.
Yes, Chair. I think that the invitation, if I may, just to be of assistance, the invitation should indicate that if he does not respond within that 7 working days, or the amount that the committee considers appropriate, it would be considered that he does not want to attend, and steps will then be taken to compel his attendance in line with the relevant powers that the committee has in terms of the Act to summon them. Because you mentioned, Chair, the reason I'm saying this, you mentioned that he hasn't responded to the committee before. So just to anticipate that, if he fails to respond within a certain time, we consider it as a refusal to attend, and committee will then proceed to compel him to attend. Thanks, Chair. That's my input.
Okay, Honorable Liz, Honorable Hadebe, is your hand a current hand or a historic hand? Honorable Liz, proceed so long.
Thank you, Mr. Chairman. I just wanted to concur, because that was indeed my original proposal, that a failure to agree to appear voluntarily would automatically result in the subpoena moving forward. So don't have any problem with that. And a failure to reply at all must have the same effect. So I think we're at Edom about that. Thank you.
Okay. Perfect. Sis Dombi, 21st, just check. Sis Buzelo, that draft program, 21st, am I right, wrong?
Yes, Chairperson, you are right, 21st.
Okay, all right. So we will...
The 20th, Chair.
20th, 21st is on Saturday.
20th, it's Friday, if we... Yes, 20th, Chairperson.
No, I'm saying the date for the meeting, to meet with him. Not the...
The 25th.
25th.
Right, 25th. Okay,
Yes.
Right, there you go. All right, so we're going to invite Brigadier Berger to appear until the 20th to respond to the committee, of which response I will circulate upon receipt. We will send that letter today, that a failure to respond or not being agreeable to appear before the committee will exercise its right to issue a subpoena, of which then the legal processes which come with it, including a sign-off by the Speaker, will have to be set into motion, and a date will then be looked at in that regard. So thank you very much, colleagues. I hope that covers everything. And if there's no other matter, we will meet tomorrow on the matters of the PRASA resettlement of persons who are living on the railway lines with relevant departments and entities. And that meeting itself too will be virtual. Are you all fine? Any other matter going once, twice, thrice? Go on. Happy Tuesday.
Long live the mighty pirates. Long live Chair.
Have a wonderful day, everyone. Take care. See you tomorrow. Godspeed. Thank you very much, Advocate, for taking us through this elaborate process today.
It's my pleasure, Chairperson. Thank you very much.